Good morning, ladies and gentlemen. My name is Sue Miller. I'm a partner in the Corporate and Commercial Dispute Resolution team here at Stephenson Harwood. I'm also head of the sanctions practice here. It's my pleasure to welcome you to this morning's seminar, where we're going to be looking at the UK's new sanctions regime following the end of the transition period on the 31st of December 2020. In this brave new world of global Britain, we're going to be focusing on some of the differences and divergences from the EU sanctions regime, sanctions enforcement trends, and if the worst were to come to the worst and you were to find yourself designated pursuant to the UK sanctions regime, what, if anything, you could do about it. Joining me for this discussion are Brian Kennelly, QC of Blackstone Chambers. Brian is an acknowledged sanctions expert, having acted in some of the most well-known cases in this area, including La Mesa, and Mubarak and the Council. Brian has kindly agreed to moderate and facilitate our discussions today. Next, we have Stephen Ashley, who is of counsel at Stephenson Harwood. He's an expert on EU and UK sanctions, especially those imposed on Iran and Russia. Then we have Jason Pobjoy, who is also of Blackstone Chambers. Jason was World ECR's Young Sanctions Practitioner of the Year in 2018 and is in the current cohort of the Lawyers Hot 100. Stephen and I have been working with Jason on a number of matters for some time. Before I hand over to Brian, I'll just say a very brief word about the format of this webinar. We're going to try and keep it as discursive as possible. We'll make some short opening remarks, but there will be no death by PowerPoint. The aim is to get a discussion going as early as possible. There's a Q&A function at the bottom of the screens. Please do ask your questions there. We will try and answer as many of them as possible as we're going through, but we will also leave time for a Q&A at the end. I'll now hand over to Brian. Thank you.
Thank you, Sue, and thank you for this very well-timed webinar. This new regime has certainly thrown up some very interesting and difficult questions, and I'm hoping to get some valuable insights from you and the other experts speaking today. So we'll hear first from Stephen, who I think is going to address us on the new regime. And so, Stephen, I'll hand over to you.
Thanks, Brian. So I'll assume that the audience has some familiarity with sanctions and the fact that the UK now has in place more than 30 autonomous sanction regimes under SAMLA, the Sanctions and Anti-Money Laundering Act. So OFCE's position is that the new UK sanctions regulations are intended to deliver the same policy effects as the EU sanctions regimes they replaced, but we are warned to assume that they are not identical. And OFCE refers to differences in drafting, but there are differences in substance. And as is often the case in sanctions, the devil is in the detail. And so just in this opening, I just wanted to highlight 4 differences relating to ownership and control in the asset freezing context, scope, payment processing and financial services, and derogations. Just before I get onto each of those, I was looking the other day at the government's impact assessments in relation to the sanctions regulations, and was interested to note that they foresaw no significant impact on the private or voluntary sector, which was somewhat surprising, and particularly because UK Finance have produced a paper setting out the changes and their impacts, which is more than 500 pages long. But in any event, I'll just talk about the 4 that I'd like to highlight. The first of those is ownership and control. And this is one major change. The UK asset freezes now expressly include the assets of entities owned or controlled directly or indirectly by a designated person. That's different to the EU position. There's no such provision in the EU sanctions, and in the EU guidance, that's a rebuttable presumption. The UK sanctions also set out a detailed definition, which should hopefully assist compliance functions, and although there is still a more woolly catch-all provision. So that's the first point. The second point is to scope, and although it does sound obvious, UK sanctions apply to the UK, and the EU sanctions apply to the EU, which now doesn't include the UK. But both of them do have some extraterritorial effect. So the UK sanctions apply to conduct in the UK by anyone or conduct anywhere else by a UK person, and the EU sanctions are similar in respect of EU persons. And that's a particular issue that we've seen for a number of years for businesses with employees and staff of different nationalities, and will only get worse now there's another sanctions regime to contend with. The other point on scope, just to briefly mention, is that the regime should be checked in each case because there may be important differences. So, for example, as I'll come on to, the licensing grounds may differ between the UK and EU regimes. So licenses may be available in the UK that aren't available in the EU. There's an exclusion in the Russia sectoral sanctions for subsidiaries. And in the UK sanctions regime, it only applies to UK subsidiaries. And similarly, in the EU sanctions regime, it applies to EU subsidiaries, which don't include UK subsidiaries. And lastly, the blocking regulation only now applies in the EU, excluding the UK, and in the UK doesn't obviously apply to the EU. The third point I wanted to highlight was in relation to financial services. So some EU sanctions prohibit financing and financial assistance. And the UK has brought this across into its sanctions regime under a different term of financial services. But importantly, the definition for financial services in the UK sanctions includes processing payments, which is different from the EU regime. So there was a case a few years ago, Rosneft, that decided that the processing of payments was not caught by the financial assistance prohibition. And in that case, actually, interestingly, so the UK argued for the broader definition, which it has now imposed in the UK, and was supported by another member state, Estonia, and interestingly, the European Commission, which of course produces the guidance in relation to EU sanctions. Germany and France argued for a narrower interpretation in that case. The other point to note on payment processing is that OFSI considers that they are also caught by the sectoral sanctions prohibition on entering into new loans, which again is different to the position at least set out in the EU guidance. The final point I just wanted to highlight in this opening is on derogations, and I'll be very brief because I've just seen the time. So there's some new derogations in the UK sanctions, at least in relation to non-UN designations. There's an exception for national security and the prevention of serious crime, and a new licensing ground for extraordinary situations, in addition to the existing ground for extraordinary expenses. And the only other point I wanted to mention on derogations is that there's now an interesting new power for OFSI to issue general licenses. So these are licenses that parties don't apply for, but that OFSI might issue to respond to unforeseeable circumstances or implementation issues, or where the government decides that it would serve the purpose of the regime better. I'll end there.
Thanks, Stephen. That's really interesting, and I've got some questions, but I've been told to keep them back until the end of the speeches. Just to remind everyone who's listening or watching to put your questions into the Q&A, and then I can pick out the hardest ones and direct them to Stephen and his colleagues when they've finished speaking. But I'll move on now to Sue, who's going to address us on OFSI enforcement.
Thanks, Brian. So I'm going to be talking about the lessons to be learned from the recent OFSI enforcement action. When OFSI was established in 2016, the then Chancellor, George Osborne, signalled the UK's intention to introduce civil penalties for the breach of financial sanctions. OFSI's powers are set out in the accompanying guidance to Part 8 of the Policing and Crime Act 2017, which appears to be taken in very significant part from OFAC, its very much larger and much more generously funded transatlantic cousin. The guidance sets out a whole host of mitigating and aggravating factors. Mitigating factors include voluntary self-reporting, which can see any resultant penalty levied reduced by between 30 and 50%, and it seems close cooperation and vigorous remediation. Aggravating factors include circumvention, professional facilitation, and repeated, persistent, or extended breaches. Now, when the civil penalty regime was announced, I think it's fair to say that many sanctions professionals were sceptical about Ofsi's ability to undertake detailed investigations. Indeed, the first enforcement actions that we saw coming through were extremely small, relating to a breach with a value of around £204 and relatively minor penalties. That all changed earlier this year when Ofsi, or rather last year, when Ofsi announced enforcement action against Standard Chartered in relation to breaches of the Ukraine sovereignty sanctions regime and the imposition of an overall penalty of £20.47 million. As a result of this action, it's now clear, if it wasn't before, that Ofsi is developing a bite to match its bark. OFAC has a reputation for imposing eye-watering fines, and that's certainly true in respect of the enforcement action in the last decade or so. But interestingly, we reviewed the OFAC enforcement actions published in the last 6 months of last year, and the Standard Chartered penalty was the biggest by a very significant margin. Indeed, a good friend and colleague of mine at the US firm Miller & Chevalier Chartered told me that OFAC had not, in fact, taken any significant enforcement action in respect of the US Russian sanctions. Very briefly, the facts of the Standard Chartered case are relate to the sanctions which prohibit the extension of loans and credit to certain Russian state banks, which came in 2014. They were amended 3 times that year. Standard Chartered initially declined to do any business with a subsidiary of Sberbank called Denizbank. It was then at least a subsidiary of Sberbank, but it's no longer within Sberbank's ownership or control. But they then sought to apply the trade finance exception. Now, that's an exception that permits transactions with a specific and documented objective of financing permissible trade between the EU and third parties. Sberbank made a total of 102 loans to Denizbank. Ofsi assessed that 70 of them, with a transaction value of a 266 million, did not have an EU nexus. And of those, 21 of them with a transaction value of 97.4 million were issued between 2017 and January 2018, and therefore fell within Ofsi's enforcement powers. Ofsi characterised those breaches as the most serious, but in light of the self-reporting and investigation of breaches and cooperation, reduced the penalty by 30%. There was then a ministerial review. Now, we knew already from an earlier case involving Telia that ministers were prepared to overrule their department. And again, this is a bit surprising. Well, it was at least surprising to this sanctions professional because I was somewhat sceptical that they would do so. But in any event, the minister considered the file, and in his consideration, in view of Standard Chartered's in full investigative report, that there was no willful breach. It made a mistake in good faith, a pretty bad one, but it made a mistake in good faith. There had been full cooperation and remediation, and he held that Ofsi should have given more weight to those factors, and therefore he reduced the penalty further to the 20.47 million that I was talking about earlier. And that's my introduction.
Thanks, Sue. Very interesting, and I'm sure we can again discuss that later. Jason is going to address us now on the vexed question of listings, that's designations, and challenging them in the new UK regime, which really is different from that which we're used to in the EU, and therefore full of open legal questions. Thanks, Jason.
Thank you very much, Brian. As Brian has just said, in my 5 minutes, I'm going to provide a roadmap for challenging UK sanctions. Given the time, I'm going to adopt the mantra of Lord Panic, that there can only ever be 3 good points. I'm going to highlight a 3-step process for challenging UK sanctions, and then I want to mention at a very high level the 3 key differences between the UK regime and the EU regime in terms of challenging sanctions, and what that might mean in practical terms for practitioners working in this area. So, 3-step process. You get a telephone call in the morning from an individual or an entity that has been designated under the UK sanctions regime. Either it's a new listing or it may well have been carried over on the 1st of January from the EU listings. Step 1, and this is always my advice to any solicitor working in this area, is on day one, apply for a licence. There is, under the UK sanctions regimes, a licensing ground that will allow a licence for the provision of reasonable legal fees. Now, of course, everybody on this call will have a different view as to what is reasonable, and there has been a lot of debate about that. In the recent guidance published by Ofsted in relation to the UK regime, they've suggested that their starting point will be the Supreme Court Costs Guide. Helpfully, the guidance makes it clear that you can provide advice to your clients prior to the licence actually being granted, but you can't receive any payment. And that's why my advice is always to get that licence as soon as possible, because you won't know what Ofsted will deem to be reasonable fees until you have that licence. Step 2, administrative review. And this is really important. You can't go straight off to the courts to challenge the designation. You have to go through the administrative review process. And that is asking a minister, the appropriate minister that was involved in the designation, to revoke or vary the designation. And I really can't emphasise how critical this stage is and the importance of front-ending the work in the context of challenging a sanctions designation. So there is a form, a sanctions review request form, which is quite a short form, but you should not be fooled by kind of how short and brief that form is, because what you will need to do at this stage is put in concrete, independent, verifiable evidence that will explain to the minister why your client should not be designated. So just to give an example, if your client is designated because they are subject to proceedings involving the misappropriation of state funds, you will want to show that actually there are no such proceedings. If there are such proceedings, you'll want to show that those proceedings have nothing to do with the misappropriation of state funds. Or if those proceedings do involve the misappropriation of state funds, you will want to present evidence that shows, for instance, that those proceedings are politically motivated or are not respecting your client's fundamental human rights. Mere assertion will not be sufficient. Expert reports from individuals engaged by your client are unlikely to be sufficient. As the guidance says, that the minister will be looking for evidence from reliable sources, evidence that can be verified, and corroborating evidence, which will be much more influential. And the reason it's so important to front end and provide the material at this stage is because by the time you get to a judicial review court, if the administrative review is denied, that is going to be your evidence base for challenging the administrative review decision. So step 3, if that decision is refused, and I should say that decision will be taken as soon as reasonably practicable. Unfortunately, there's no more guidance than that. But if that is a negative decision, that's when you can go to the High Court. And the legislation makes it clear that the High Court will be applying judicial review principles, although there are limits on what the circumstances in which you can get damages. So 3-stage process, but in my view, it's the second stage that really is the most important stage, and it shouldn't be something that is rushed. It's something where you should put your best foot forward. 1, to try to convince the minister that the mistake has been made, but 2, to give you a solid evidential footing for any subsequent judicial review challenge. 3 key differences with the EU regime. Difference 1, the administrative review process, which I've just outlined. Although there is a review process with the EU Council, it's now, in the UK, it's far more formal. It has a statutory footing, and you know precisely what the minister is going to be looking at. There is a periodic review process in the UK. It's every 3 years, so that's another significant difference. In the EU, it's every year. So the reviews are going to be undertaken less often in the UK. And after you've asked for an administrative review, you're not permitted to ask for another one unless there's been a significant change in circumstances. So the cases are going to be reviewed less often than in the EU. So difference 2, and although we don't have any evidence of this yet, as the process is so new, I anticipate, and I think this is a general view held amongst practitioners working in this area, the administrative review process will be dealt with in a much more robust fashion than it is currently being dealt with by the council. And I say that with all due respect, and the council is getting much better at this review process when it undertakes it periodically, but there are still problems with the process, and I've certainly had experience, as had Brian, where we put in 3, 4, 5 lever arch folders of material, and there's just no engagement whatsoever with any of that material, and you get a 1-paragraph response after the redesignation explaining that they've decided to redesignate. So we're hoping that you get much more thorough reasoning in response to this administrative review process, and more engagement throughout that process. And difference 3 is that you will now be in the High Court judicial review, applying judicial review principles. So the standards are going to be very different. I anticipate that decisions, the reasons for the decisions, whether the requisite evidential standards have been met, are going to be much more closely scrutinised by the courts. And it will be very interesting to see, for instance, if where designations have been carried over from the EU, and there have, for instance, been kind of repeated unsuccessful attempts to challenging those EU sanctions, whether a different approach is taken by the UK courts, applying very well-established principles of rationality, proportionality, and procedural fairness that our courts here are so familiar with. So it'll be very interesting to see the difference in approach, but I do think there will be a difference, and that the decisions are going to be subject to much more scrutiny than they are at the moment in the European courts. So there we go, 3-step process, 3 differences, but it's very much watch this space. And I think there will be a really interesting and exciting body of case law that fast develops in this area. Thank you.
Thanks, Jason. So now we're switching to Q&A, and again, I encourage the participants, and I see there are quite a few of you, to put your questions into Q&A, and I'll refer them on then to the panel. But just to open with some questions of my own, and Stephen, this is directed to you, because I was very interested to hear about the existing express divergence between the UK and the EU regimes, which we now see. But of particular interest, of course, is where that divergence is likely to increase or develop as these provisions are tested in the courts. What experience do you have of that divergence happening already, and where do you expect it to arise in the future?
Thanks, Brian. Well, I think one area that we've seen quite significant divergence already is in the names of people designated. So the UK, for example, did not carry over any of those people designated by the EU under the misappropriation sanctions, so related to Egypt, Tunisia and Ukraine. Perhaps, and I'm speculating, because the EU has lost a number of cases in the EU courts in relation to those sanctions regimes. But the regime itself is there. There is a UK regulation relating to the misappropriation of assets, but no one is designated under it at the moment. The other areas are again related to designation. So since the beginning of the year, the UK, so for all the talk before the end of the transition period about coordinating sanctions, and that multilateral sanctions are much more effective than unilateral sanctions, we've seen differences in designations. So since the beginning of the year, the UK has designated some security officials under the Zimbabwe sanctions, which aren't EU designated. There were some individuals designated in relation to the Belarus elections in mid-February, I think, who were designated by the EU in December. So a big gap between the asset freezes applying to those individuals within the EU and the UK. And again, we've seen it in relation to Myanmar and the military coup. some designations from the UK, which seem to have been coordinated with the US, although the US designations were again earlier, so a gap in time, and no designations from the EU. And then just this week, we've seen the EU coordinate with the US in relation to designations under the new EU global human rights sanctions regime in relation to the Navalny detention in Russia. And the UK hasn't yet designated anyone in relation to that detention. There were some designations last year under the EU sanctions regime in relation to chemical weapons, which the UK carried over. So we can already see a huge divergence in terms of the people who are being designated. And that's only making the situation worse when the potential scope of the sanctions are different as well. The other area just to flag in terms of potential scope for divergence going forward is the global human rights sanctions regime. So not only are the designations different at the moment and unlikely to converge, but the scope of the sanctions regime between the UK and the EU is different as well. Again, it's interesting to see, given the UK's position, that it was going to, or it intended to, try and coordinate sanctions, and its long-held position that multilateral sanctions are more effective. It's only going to create more headaches for businesses and compliance functions.
Yeah, I mean that's the headache point obviously resonates very strongly because, and this ties into the questions that we're seeing in the Q&A. Even though the UK is going its own way, the reality for many businesses, many international businesses, is that they've got to comply with EU sanctions and UK sanctions at the same time, because the territorial scope will overlap in many instances. And so, for example, one of the questions is, what if it's say a UK entity trading in Germany or a German entity trading in the UK? Well, plainly, it's going to have to comply with both sets, and where they're construed in a different way, that makes the same provisions or similar provisions may be construed in a different way. That generates a real compliance headache for the business in question. I mean, I'm personally very interested in the way that Russian regulations will or may diverge, because although the language is similar between the UK and the EU, and the guidance, of course, is similar as well. We've seen OFSI tracking very closely the EU guidance on Russia. My personal view is that some of that guidance really stretches the literal meaning of the words, and I wonder whether the English courts will take the same view as the OFSI guidance. I mean, the example that occurs to me that ties into one of the questions that were asked is on loans and credit. How will loans and credit be construed by the English courts when they're free to apply their own English principles of construction to those words? We know in the guidance that both the EU and OFSI include within loans and credit a free grant of cash, which doesn't fall literally within the meaning of those terms. It's more like financial assistance, but that's not the same thing and not covered by the same provisions. And so, I mean, in terms of those provisions, Stephen, do you have any sense of where the problems will arise on the particular financial services aspects?
I can only echo what you said, that these are areas that are going to need to be ultimately resolved by the court, because it is difficult to accept some of the guidance that come from the EU and UK. So, for example, another example in the Russia context, both the EU and OFSI guidance say that payment terms of more than 30 days are not necessarily caught by the prohibition on loans and credit, unless they are used to circumvent sanctions. And the EU guidance goes a bit further and says that where they're in line with normal business practice, then that won't be circumvention. But the US position is the complete opposite, and says that payment terms of more than 30 days are caught by their equivalent prohibition, which is very similar to the EU and UK provision. ultimately, this is guidance from the authorities in the UK and EU, and is non-binding. So we'll have to see how it plays out. I mean, I should say, as I mentioned earlier in the Rosneft case, the European Commission, which produces the guidance, was on the wrong side of the argument as to how broad financial assistance should be interpreted, and the court said that it was much narrower than the Commission had been arguing for. So if it's in the guidance, it's not necessarily correct, but until a court rules, I think we have to take some comfort from the position that's set out in the guidance, and that businesses can rely on the position that OFSI presents as being the sanctions position.
Yeah, and in fact, and again, just addressing the questions that have been put to us in the Q&A, you have to always recall that even if the particular services are not caught by sanctions, say under the UK regime, because they've been construed more narrowly than the EU regime, if there's deferred payment for those services, that deferred payment can itself be a loan or credit, which is prohibited. So I think that goes to that first question that we were asked. And I suppose just on wrapping up on this point, I see that we're asked about, where can firms find answers to these vexed questions? And if there was an easy answer to that question, we'd be out of a job. Unfortunately, there isn't a single comprehensive repository of learning on these issues. The banks, like ourselves, are forced to have recourse to the jurisprudence of the courts and the fairly limited guidance published by the EU and now by OFSI. Beyond that, unless Stephen or Sue or Jason, you've got some valuable insights on this question, I'm not sure what else there is to help stakeholders.
No, I mean, I would say that the US has been much better, and OFAC, in producing reams of FAQs, which are much more helpful. The EU and UK have been getting better. At least we have some guidance now. It used to be the position where there was none. So there is some available, but it doesn't deal with the really tough questions. Anyway, it really deals with the easier ones, I suppose.
And I suppose one of the problems with this is that the uncertainty is all the more worrying when OFSI is flexing its muscles and increasing its enforcement actions. And Sue, in respect of that, I mean, how do you feel OFSI is going to recognise the novelty of the regime and the uncertainty that surrounds it as it becomes more aggressive in the enforcement of these new provisions?
I think you'd like to think that they would have, they would be prepared to give a period of grace where businesses adjust to the new regime. But I'm not exactly convinced by that, because I think OFSI's position would be, well, prior to the end of the transition period, we engaged in an extensive period of consultation and webinars and outreach to various industries, financial industry, to lawyers, to this, that, and the other. So my guess is it would depend ultimately. OFSI's position is likely to depend on what their view is of the severity of the breach. If it's technical and minor, then I suspect they would take a reasonably relaxed view and engage in guidance. If something rather more serious goes wrong, I suspect that they would be looking to exercise their full enforcement powers.
Sure. And Sue, since I have you, I was very interested in that Standard Chartered decision. And although OFSI is now taking a more aggressive stance, in some ways that decision reflects a surprising level of mercy, in the sense that credit was given for cooperation. That's a standard OFSI position. Of course, at the same time, OFSI stresses that firms have a positive duty to provide that information. I mean, how do you see those two things being reconciled? The duty to positively bring those problems to the attention of the regulator, and then credit given for doing that very thing.
I suppose the short answer is it's quite difficult to reconcile, at least when we're talking about the regulated sector, when there has been a positive duty to self-report from the very beginning, I guess, of sanctions being introduced. In around 2017, that was, I think, extended outside the regulated sector to lawyers, estate agents, auction houses. But I suppose ultimately the position that OFSI is taking on this is that they want to have a positive incentive to be informed of breaches as soon as they arise. And notwithstanding the various obligations on the regulated sector, the best way of incentivizing early reporting is to provide discounts in circumstances where you have reported early. And then, of course, it goes to the whole question of, how have you cooperated in the investigation? Have you done a sort of full mea culpa, open kimono exercise, or are you trying to hold various things back? In the US context, I've seen that basically they tend to operate on the basis that, if you waive privilege, we'll see that as being, an example of a cooperative approach. Now, I haven't seen that in the UK context, but I don't know whether that's coming.
Yeah, when you mentioned the US context and the approach of the regulator there, it does bring firmly back into the agenda the blocking regulation, and the UK's own domestic version of the blocking regulation, which has caused a huge amount of confusion and litigation over the last few years. And Jason, I know, covers this extensively, and we litigated the La Mesa case together up to the Court of Appeal. Jason, where do you see the UK's blocking regulations creating difficulties for businesses? Is it possible that, in combination with more detailed guidance from OFSI, the open questions will be addressed to a greater extent here than they have been in the EU?
Well, I very much hope so. I think it will show how unexciting my life is, but it's fair to say that I've lost several nights of sleep worrying about this instrument, which is extremely difficult to navigate, and really has put individual, even though it does clearly pursue some legitimate aims, it's put individuals and entities in really difficult positions between kind of a rock and a hard place. And on the one hand, needing to comply with the blocking regulation, which gives rise to criminal offences. On the other hand, needing to comply or wanting to comply with contractual obligations and being at risk of breach of a court order or breach of or breach of a contract. The blocking regulation is retained, has been retained into UK law, but with some modifications. So there is a regulation which the government's calling the protection of trading interests of legislation. And I think the signals that we're getting so far in the guidance are positive, and there's one key change which I think will be very helpful for businesses. But the guidance that certainly the guidance I've read so far seems to be suggesting that this is far more about trying to protect and balance the protection of businesses' interests rather than having some kind of punitive effect on businesses. And I think the key way that they're going to do that is by way of this authorization process, which there's now much clearer guidance on. If a business can show that they will suffer kind of serious impacts if they don't comply with US secondary sanctions, they can apply for one of these authorizations. And I think there have already been at least one granted, and the UK government is publishing those authorizations, so you can see these online. And even though there was, as people on the call will know, under the blocking regulation, even though there is an authorisation process through the Commission, it was very amorphous. No one really had any idea how it was operating, how often people were applying to the Commission, whether the Commission was granting these authorisations, etc. So having a far more transparent approach to authorisation, I guess potentially, if authorisation was refused, you could potentially even challenge that decision. So I think there'll now be kind of greater scope to circumvent. That's probably an unfortunate use of word, but to deal with the challenges that are faced. Because at the moment, when people have come to me for advice, often it's just kind of there's very little that can be that could be done, and you see that in the Lemessa litigation that Brian mentioned. So I'm hoping that we're moving in a positive direction that will better balance the interests of the various parties involved.
Yeah, I mean, I found that really interesting, the publishing of the authorizations. I mean, the whole licensing regime has been a black hole for decades. I mean, one can understand why, in many cases, one couldn't publish licensing decisions because they're highly confidential, they're in relation to confidential transactions. But there must have been some scope for publishing redacted versions or summaries of licensing decisions. And so having the authorizations published gives us all a really valuable tool in advising on how this regime should operate in the future. And as you say, it means greater transparency, which can only be a good thing for all of us in this field. But on the subject of licensing and exemptions, Jason, again, we've seen that the licensing and exemption provisions are broader and slightly different in the UK regulations than they have been in the EU. And I mean, what are your views on this question? Because this, again, seems to me to be an area where we're going to see divergence, and maybe welcome divergence, because the EU regime, in many ways, was far too restrictive and unjust.
I think that's right. I think the key change is, and no doubt because obviously would have been involved in the design and the design of these new schemes, and would be well aware of the challenges and the lack of flexibility that it had in terms of granting licenses. And in the context of many of the EU regimes, there just isn't scope for any discretion, and that can be problematic because there will be instances where it will clearly be legitimate proportionate to grant some form of exception, but there's just no scope under the licenses. And Stephen and Stuart and I have certainly faced that in some of the work that we have done. The two that really stick out to me, there's now this provision for a general license, and again, these are being published. I think one has been published so far in relation to Crimea, which applies to kind of multi-parties doing something that would otherwise be precluded by a sanctions regime, and it's a pretty broad discretion, and it's not limited at all by any of the individual sanctions regimes. So that's one key change. And the other thing that jumped out at me was this kind of notion of extraordinary situations, and most of the regimes will allow for a license in an extraordinary situation. So it will be interesting to see how that gets used as well, Stephen. So I didn't know if there were any other examples that jumped out at you, but they were the two for me. And it gives OFSI some flexibility and some discretion just to be sensible. And I've had cases in the past where for instance, a client has decided has not paid a bill for legal fees, and those legal fees are still sitting on the ledger because obviously have told us that you would actually need a separate license to write off those fees, and there's no licensing exception under the relevant regime that would allow that form of license, which is just extraordinary. So anyway, Stephen, I didn't know if you had another example.
No, I agree with you that those are the two most interesting points. Just on general licenses, I would just add that OFAC have had that power for some time and have had much more flexibility in being able to issue licenses. And I mean, you just need to go on their website and you'll see they've issued a huge number of general licenses. So it will be very interesting to see how Ofsted uses this new power. As you say, they've issued one already, which they did immediately at the end of the transition period. Interestingly, that license relates to prohibitions that were carried over from the EU sanctions. So one presumes that if a party is making use of that general license from the UK and they are subject to the same EU sanctions that they must have sought or must be seeking or should have sought, individual licenses from the relevant EU authorities as well, which highlights another possible issue, is that although Ofsted has this hopefully useful new power to issue general licenses, that they may not be available, the equivalent license may not be available in the EU unless it can be fit within one of the very restrictive licensing grounds.
I think that's right. I think the potential breadth of the general licensing provision, you can see from the guidance. I thought the example they give in the guidance was quite telling, which is, say, for instance, the government comes up with a new financial services policy, which is incompatible with the sanctions legislation. We could just make a general license which would allow for that policy. So it has got quite extraordinary breadth and as you said, it'll be interesting to see how it's used and whether it's used to the same extent as the comparable provision is used in the US.
Yeah, and the interesting thing is that how it could be challenged. I remember in one of the Ahmed Ez cases, we sought a license. I think we were seeking a license for the designated individual for the purposes of bringing an action in the UK, and Egypt. And they said this in open court, threatened to judicially review a decision to grant the license because the money was allegedly misappropriated Egyptian state funds. So these points may be tested not only by the people seeking the license, but those whose funds have been allegedly misappropriated. And on the subject of designations and challenges, again, Stephen, Sue, Jason, just opening up, the points that Jason made about ministerial review and then court challenges after that are obviously very interesting. I mean, have you heard anything on the ground about how whether people are teeing up to use this ministerial review process already? How much activity are we likely to see in the short term?
I can just say that really quickly. I had anticipated that there would be quite a lot very early on, because I had anticipated wrongly that the UK was going to carry over all of the designations in relation to misappropriation of state funds, and they haven't done that. And I'm sure that Stephen's speculation is probably accurate, and that's because the EU Council kept losing these cases, mainly because of Brian, but
and Jason.
And so all of those individuals, well, I think it's fair to say that the basis of at least some of those designations is quite weak, would likely have challenged in the UK courts, but there's been no need because the UK, I think, took the very sensible decision of not carrying those designations over. I'm not aware of any JR that's been issued. I have heard on the grapevine that some designated individuals have started going through the administrative review process. I imagine, given that the only commitment is to take a decision as soon as reasonably practicable, insofar as any of those have started, none of them would have been complete yet. It's not clear to me, and there may well be guidance on this, and Stephen, Brian, so you might have the answer. It wasn't clear to me whether or not the reasons following a ministerial review were going to be published or not. I certainly haven't seen any published. It will be interesting to know whether or not. I guess if they are going to remove an individual, then that will have to be published. So you will hear about that because their name will be removed from the list. But that's all the insight I have, I'm afraid.
Yeah, I'd say that accords with my view. I mean, I think the thing that's interesting is, the ministerial review taking place as soon as reasonably practical. What does that mean? And it raises the spectre of the US, the equivalent US regime, where you ask the authorities to reconsider and it goes into a black box and you don't hear anything. I mean, how do you get that going?
I think that's a really important issue, Sue, because this is a context where if somebody has been designated unlawfully, the effect of these sanctions can be extremely draconian. And if you use a really extreme example, which certainly happened repeatedly at the EU level, of somebody being sanctioned just because they've been totally misidentified. So it's just a case of, well, you've got the wrong person, guys. And one would hope that in those cases, that administrative review process moves extremely quickly. I've seen a more complicated case where your argument is about, well, the relevant evidential standard hasn't been met or the relevant criteria aren't satisfied. It's going to take them a little bit longer. And I'm sure for the first few decisions, it will take time. But if we're going to be talking about 3, 4, 5 months, that is a significant period of time in the lives of the kind of these, particularly when we talk about individuals, and particularly if the outcome of that review is that they should never have been designated. So I wouldn't be surprised if we see kind of satellite litigation challenging delays if there are in fact delays. I think it's a really important issue.
And just to broaden it out then to the broader policy questions, and I suppose this is something where maybe Stephen and Sue have insights from dealing with the clients that you have. The way the UK has developed this new policy, for example, by not carrying across the asset freezes for Ukraine and Egypt and so forth, does tend to suggest that the UK is taking a different approach in exercising this foreign policy tool. And we see the Foreign Office obviously referring to the situation with the Uyghurs in China and a lot of saber rattling on the Magnitsky sanctions. Where do you see the UK's foreign policy focus in the future using this sanctions regime? And in particular, how that will interact with the new US approach, which has been flagged by the Biden administration?
I think we'll see a lot more human rights designations. I think the government will feel more comfortable on human rights designations than in some of the more controversial areas where they will be trying to tread a very fine path between what might be US policy and, and in certain respects, the US policy seems to be at odds with the EU policy.
Yeah, I completely agree. I think the new global human rights sanctions regime is going to be used a lot. And interestingly, just I think in December, there were a number of designations by the UK under that regime. And some of those, if not most of them, were sort of historic, quite historic human rights violations. So I think that's an area where the government feels more comfortable to target people. And it's certainly an area where Parliament is putting more pressure on the government to target people. And it will be, I think another area that related to that we might see in future is expanding the scope of that regime. As I mentioned earlier, it's limited to particular human rights violations. So although the UK says that it's not putting them in any order of precedence, it only applies to particular ones. And so, for example, there have been calls in Parliament to extend it to bribery and corruption and things like that. So I think that's an area that's going to be a big focus of the government going forward.
And how do you think that's going to interact with the EU? Because I mean, already we see divergences between the US and the EU foreign policy. Iran is the classic example. How can the UK walk that line between using, in particular, the human rights provisions to coordinate with the US, but at the same time maintain a coordinated position with the EU?
It's a good question. I mean, we'll just have to see how coordinated it is. As I say, the UK's designations don't appear to have been particularly well coordinated with their international partners so far, despite what they had said when they imposed that regime. There'll obviously be policy differences between the UK and other countries, and in between different administrations. I mean, we only have to look at the different foreign policy positions of Biden and Trump. Iran's a good example. So Biden now talking about moving back towards the JCPOA, which obviously Trump pulled out of and reimposed a whole slew of secondary sanctions, which are causing numerous difficulties with the blocking regulation. But I don't think there's an easy answer to your question. There's always going to be differences, and unfortunately, in the sanctions sphere, those differences end up causing real issues for businesses.
Yeah, and on a depressing, I suppose, well, not unexpected, but slightly depressing note, those are the questions I had, and I hope I've carried across the questions on the Q&A. So, Stephen, Jason, any closing remarks before we get back to our day jobs?
The only thing that I would like to do is to thank everybody for their attention and their active participation in this morning's discussions. The webinar is being filmed, and so it'll be posted on our website in case you do want to relive the experience or indeed recommend it to any interested colleagues. So I'd just like to thank all of the panelists for their participation, Brian for his expert moderation and facilitation, and again, everyone else for joining in. So thank you so much for attending, and goodbye and take care, everybody.
Thank you.